is right, my lord. Universal has, I didn't want to name the publisher, but Universal has this mistake.
Repository in India.
So, my lord, the political solution, my lord, of a problem. Sometimes executive, my lord, is confronted with some problem which needs to be resolved by using legislative means. My lord, there was that all right. Your argument that from 51 onwards everyone should not get citizenship. You come down to 66, my lord. They agree, and from 66, the contention was that this large number of influx, and when I show the figures, my lord, uh, the figures, my lord, the time at which the figures are shown, the population of Assam was say 1 crore, and the influx was 10 lakhs. So 10% influx, my lord, changes, my lord, right of political participation and right of political decision making, right of jobs. My lord, all of them didn't, after 71 at least, nobody came, my lord, because of any war situation there. Up to 71, it can be understood. Because of economic beneficial position in this part of India, in India, Lord, the land holdings were very wide, very huge land holdings. Lord, the population density was very less. The job opportunities were less. So they came for economic reasons.
They are challenged both subsection 2 and subsection 3, right?
Yes.
They're challenging the entirety.
The
arguments seem to have been more focused on 3 by Mr. Diwan.
Yes, yes.
But the challenge is
challenge
to the entirety.
They have challenged both. But I'm just not justifying. This was not possibly because what transpired in the meeting between the Prime Minister and the ASU leaders, because I have read the Honorable Prime Minister traveled to Assam and held meetings, my lord. So this appears to be, my lord, a via media which is found out that you don't insist on 51. You come down to 66. Then 66 onwards, we will restrict it up to 71 because 6A says whoever comes after 71 would be an illegal immigrant. No benefit, no nothing. Only foreigners tribunal would decide and you will be deported. But their contention that they are changing the political scenario, political representation, etc. Therefore, my lord, this via media was found that for 10 years, namely till the decision of foreigners tribunal is taken, you will not have a right of participating in the election. And that right came, my lord, only after 10 years of the declaration.
What's the date of the surrender of the Pakistani army actually when Lieutenant General Niazi,
16th December 1971. General Niazi and
General Arora on our side.
And Jagjit Singh Arora on our side, my lord. And one Mr. There was a Christian fellow. Peter. No, Sam Maniksham. General Jacob, yes, my lord. He was also instrumental.
He was Major General.
Yes. No, Major General was, my lord, Jagjit Singh Arora.
That's right.
But Mr. Jacob was, I think. But Lord, he was, I'm sorry, I stand corrected.
Lieutenant General Jagjit Singh Arora, and if I'm not mistaken, Major General Jacob. Jacob was a Major General.
Jacob, my lord, he was, Jagjit Singh Arora was General Officer in Command of Eastern Command. GOC in command, as they say.
So interestingly, I mean, it may or may not have any bearing on constitutional validity. The cutoff date which is chosen, 25th March 1971, excludes all those who came in during that period of flux in Bangladesh, because the cutoff date is not 16 December 1971, it's 25 March 1971. So anybody who came in, that's right, that's what he just said. But therefore, anybody who came in after Operation Searchlight has been excluded from the benefit of such citizenship. Yes. So the Bangladeshi influx which took place as a result of the genocide in Bangladesh, they have been excluded by
because the Prime Minister of Bangladesh said that we will take them back.
They had a cutoff of 25th March 1970.
Because the Honorable Prime Minister of Bangladesh said that we'll take everyone who came after 25th March
Back
71
into our country.
back into our country. Lord, rest of 6 and 7, I'll just orally say, somebody can say that I don't want to get benefit of this. That's all. No, nobody is questioning 6 and 7. And Lord, it is very clear, Lord, from the section that after 71, all are illegal immigrants subject to being so declared by the.
Now we've got the statutory scheme. Now we can go straight to their arguments and address the
yes.
submission.
Yes, Lord, if your lordships, my lord, there was a question, my lord, about Rule 19, that which came into force in 2013. My lord, I wanted to answer that question so that I can complete the chronology. My lord, your lordships have seen that 6A will be operated as per the rules framed under Section 18, my lords. Because, my lord, the first impression of everyone was that what happened till 2013. Even the rules are 2009. So there was no vacuum. My lord, that's all I wanted to say. My lord, nothing may possibly turn on that. But just to complete the history, my lord, and the chronology, my lord, Section 6A says that this process will be done as per the rules made under 18EE, small e. That is, my lord, confined to 6A. 18EE, my lord, if your lordships can see. It says 18, but EE, my lord, is I have found, my lord. It's not entire 18, but 18EE was also, my lord, amended.
And that came in by the same amending act.
But yes. Now, immediately thereafter, citizenship rules were framed in 1956, were amended, I'm sorry. Citizenship rules were already in existence since 1956, but they were amended to bring it in conformity with newly inserted Section 6A. If your lordships would like to have the date, they were amended on 15th of January 1987 to give effect to, my lord, Section 6A. That your lordships would find Volume 4C.
Give effect to rule of Section 6A.
Volume 4C, page 3. Page 3. It starts at page 3. I'm not, my lord, none of us, either side, my lord, are required to go through 4C, volume 4C. Roman 4, Roman 2. Please come to internal page 8, or my lord, PDF page 8. PDF page 8. 16 capital D was inserted.
Just a second.
Lord, your lordships may allow me to read, my lord, so that it would give, my lord, some assistance why 2013 amendment was required to be brought in. A reference to tribunals, where in the case of a person, your lordship, my lords,
where are you reading?
Justice
What are you reading from that volume 4C you're reading?
4C, para A, page 8.
Page 8.
These are the rules of 56, amended in 87 to deal with 6A situation.
16D.
Where in case of a person seeking registration under subsection 3 of section 6A, any Lord, I may not read, but there is a reference provision because nothing turns on that. Then 16E is jurisdiction of the tribunal, which says that it would decide the reference under subsection 3 of section 6A. Last line, my lord, of page 8.
Yes.
Now, please see 16F. Registering authority for the purpose of section 6A3 and form of application for registration. Now, please come to 2, subrule 2. An application for registration under subsection 3 of section 6A of the Act shall be filed in form 23 by the person with the registering authority for the district in which he is ordinarily resident within 30 days from the date of his detection as a foreigner, where such detection takes place after commencement of the rules, or within 30 days of the appointment of registering authority for the district concerned, where such detection has taken place before the commencement of the rules 1986. Well, there was a time limit prescribed for registration. If I am declared a foreigner and therefore entitled to the benefit of 6A, I'll have to get it registered within 30 days. Lord, the government, from the file, my lord, it appears, and I have, my lord, those documents also, that there were concerns that it is not possible to do it within 30 days. So, though we are declared, we have a order of the tribunal, we are unable to get ourselves registered.
So therefore, then they brought in the 2013 amendment to rule 19, and said now 30 days after we issue this notification of these.
That's the reason, my lord. Just to complete, this is, my lord, the note of the then Home Secretary giving the justification for amendment in 2013. Nothing, my lord, may turn on that, my lord, but just to complete.
See, now we get some data. It is pointed out that on July 2012.
I'll read.
Right, okay.
It is pointed out that as on July 2012, 32,537 number of persons were declared illegal immigrants pertaining to 6671. So there are other data also in my affidavit. I'll show, my lord. Stream by the Foreigners Tribunal. Of this, 12,914 number of persons have registered themselves with the registering authority. The remaining persons could not register with the registering authority due to variety of reasons, including expiration of limit of period of 30 days for registration. As a result, a number of cases have been filed before the Guwahati High Court indicating reasons as to how they could not register with the registering authority and praying that limit of the days for registration be relaxed. It would be difficult to repatriate or deport these category of persons to Bangladesh in view of the understanding between the two countries that persons who came to India up to 24th March 71 would not be repatriated to Bangladesh. Eventually, these persons will become stateless persons if they are not allowed to register with the registering authorities. This is a genuine difficulty being faced not only by the state government but also by the identified persons. In view of the above stated positions, it is proposed that rules may be relaxed as suggested in para 5 of the notes on page 1920. N is note section. May your lordship knows, my lord. So and so. So, my lord, this is how, my lord, the amendment came. First, my lord, 2009 rules came, and thereafter they were amended in 2013.
One very important circumstance which this note of the Home Secretary indicates is that as we found from the joint communique which was issued in on February 8, 1972, Bangladesh assumed unconditional responsibility to take back those who had come into India after 25th March 1971. Implicitly meaning, therefore, that people who had come into India prior to 25 March 1971, there was no question of deporting these people because Bangladesh would not be willing to take them back. If they were not conferred citizenship, they would be rendered stateless because they would not be going back to Bangladesh. And therefore, it was in that sense a solemn obligation which was undertaken by India in terms of an understanding with Bangladesh that pre-25 March 2071 would remain. And then we must also read it in the context of entry 10 of list 1, which says foreign affairs, all matters which bring the union into relationship with the foreign country.
Correct.
And therefore, the power under Article 72, the executive power would also extend to entry 10. So in that sense, an international understanding between the then Prime Minister of India and the Prime Minister of Bangladesh that they would take back post 25 March 1971. Now, what would you do? These were not illegal. They couldn't be pushed out of Indian territory as illegal immigrants.
So extend the time and give them more time to get
Therefore,
themselves registered.
Therefore, the tacit understanding was that they would remain in India. You couldn't push them out back to Bangladesh because that was not the obligation which was assumed by Bangladesh. Therefore, instead of maintaining them as stateless persons in India, at least bring them into the mainstream by conferring the citizenship on them.
Just as a proposition of law doesn't arise here. Doesn't arise here. Lord,
71, post 1971, there's no question of 6A doesn't
even Bangladesh agreeing to take them back, yes, not agreeing to take them back.
They don't have, they don't even
they agree to take them back.
They
agree to take them back. Post 71.
Yes.
Post the cutoff.
And they don't even come to the zone of citizenship.
Yes. So they are illegal immigrants.
And therefore, at some point, we'd like to know from the government, what is the government doing in respect of those persons? Because their grievance
in regard to those. The really serious issue. We have said, my lord, what we are doing, but something more is required to be done. Because there is, my lord, demographic change and, my lord, there are several problems. My lord. Therefore, I started by saying that their concerns, their problems are not, my lord, I'm not trivializing. I'm saying they are correct problems. I'm only defending 6A, that's all. Just limited
the communication, the Honorable Prime Minister of Bangladesh also acknowledges that.
Yes.
There are scores of others who entered illegally thereafter.
Lord, whenever they say,
they will be taken back.
Whenever Bangladesh, the sovereign of Bangladesh says that before 25th March 71, we will take them back, it implicitly gives an assurance that after that, nobody will be permitted to cross over. That's how, Lord, the international relations operate.
Also, Mr. Solicitor, there's one other dimension that pre-25 March 1971 would comprise of two groups. People who have been granted citizenship, everybody before 66 becomes a citizen, right? After 1166, everybody qualifies for being considered for the grant of citizenship, provided conditions are met. Those who are granted citizenship would become a part of our mainstream. Those who are not granted citizenship, you can't push them out anyway because Bangladesh is not going to take them back.
Then, my lord, it's not necessary for them. Their agreement is not necessary. If they are not granted citizenship, it would not be possible. That contingency may not arise because if he is unable to show that he is a foreigner, then, my lord, he is a citizen of India. But if suppose somebody suspects that so-and-so is a Bangladeshi, I go to the foreigners tribunal and say, no, you are not a foreigner. That means I am a citizen of India. If I am a foreigner, before 71, I'll get the protection of 6A. And if I am declared a foreigner after 25th March 71, then I'll have to be, my lord, as per law, pushed back to Bangladesh.
Point.
My lord, please now come to, my lord, some facts and figures. Volume 3, my lord, the affidavit filed by State of Assam, it starts at page 969. My lord, there are several affidavits filed. My apologies. My lord, this is the affidavit dated 5th December 2014, page 969, volume 3. Well, there are several affidavits filed by both Assam, state of Assam, and the central government, but I'm not troubling your lordships with my lord, other contents, my lord, which are not. 969, affidavit dated 5th December 2014. Six nine six 969. But the relevant part would be page 982. I'm not going to read anything, my lord. I'm just giving the details which were placed before your lordships. And whatever is relevant for the present purpose and whatever may answer my lord's very pertinent queries, my lord, I'll show. Because affidavits are very long affidavits, etc. My lord. My lord, now please see page 982. Your lordship gets, my lord, page 982. Number of cases, my lord, Chief Justice was. Number of cases before the Foreigners Tribunal and their disposals. The details of cases pertaining to January 166 to March 2471 referred to the Foreigners Tribunal between 86 to 31st July 2014, because this affidavit is filed in December 14. The figures are as on that date. Total number of inquiries.
Volume 3.
I'm sorry.
Page, PDF page 982.
PDF page, my lord, is 982.
Yes.
There is a chart, my lord, Justice Sundari.
Yes, sir. Yes.
There is a hazy chart, my lord. It's a scanning of a Xerox, my lord, possibly. That's why it's hazy.
Yes.
Total number of inquiries initiated for period relating to January 66 to March 71. 52 lakhs. 5 lakh 20. 5 lakhs 20,438. Number of inquiries completed 5,22,326. Number of cases referred to the Foreigners Tribunal 42,000. Number of cases disposed of by the tribunals 31,105. Number of persons declared foreigners for period relating to January 166 to March 24, 32,969. Number of persons whose names were sent for deletion from the electoral rolls, the same number. My lord, your lordship knows they are disenfranchised from the date of the declaration. Total number of persons registered with the registering authorities, 13,914. Total number of persons declared as bona fide Indian citizens for period relating to January 166 to March 24, 71, 27,078. Total number of
who got citizenship as of the date of this affidavit is about 27,000.
So, yes.
And 11,000 cases are pending.
11,000 cases are pending. And details of cases pertaining to the difficulty is
71 and 8. What about
that is next. That is next. That is, my lord, alarming. And next chart is not covered by 6A.
Functioning.
Date on which it was inserted and came into force?
7th December
I just will
1985.
achieve the
7/12/1985.
Ah. That is why they have taken it.
7/12/85, my lords.
That is from 86 onwards.
Yes. Now, my lord, the second chart, my lord, is little alarming. Details of cases pertaining to the period from March 2571 referred to the IMD tribunal. My lord, there were earlier,
There were tribunals, some tribunals were there.
my lord, earlier there was IMD tribunal, my lord, which was set aside in Sonowal judgment, with which your lordships are not concerned, but there was a tribunal. To IMD tribunal and subsequently transferred to foreigners tribunal after scrapping of IMDT Act. Plus, scrapping means it was declared unconstitutional between 83 to July 31, 2014. Total number of inquiries initiated on or after March 25, 71, 76 lakh 7, I'm sorry, 7,67,927. Then two, number of inquiries completed under IMD Act and total 7,44,820. Number of cases referred to IMD tribunal or foreigners tribunal 41,000, 4,19,258. Number of cases disposed of by the IMD tribunal or foreigners tribunal 1,87,294. Number of persons declared foreigners, illegal immigrants on or after March 25, 71, 35,000. Number of persons whose names were sent for deletion from electoral rolls 35,969. Then total number of persons declared as bona fide Indian citizens on or after March 25, 1971, 64,594. Lord, I'll just clarify this. Lord, they may be falling within 6A, but their decision comes late. Foreigners Tribunal, my lord, took decision late, or there may be a challenge before the High Court, Supreme Court, remand, etc., etc. The total number of cases where alleged persons are not traceable, that is 53,000. Because they enter from Assam and, my lord, spread all over. Mr. Diwan was, my lord, that's why pointing out that they have settled in Delhi. Some of them have, my lord, gone as back as far as, my lord, Jammu and Kashmir, etc. Then total number of persons deported, 2,447. Total number of cases pending before the tribunals, 2,31,000. This needs to be, now subsequent affidavit says that we have increased the number of tribunals, etc. But my lord, something more definitely needs to be done. My lord, I will not defend the undefendable. Now your lordships may, my lord, come to the center's affidavit dated 5th December 14.
This affidavit of Joydeep Shukla is of what date?
5th December 2014.
Earlier one, which you showed us, right? Earlier one, the previous
Earlier,
one.
that both are of the same date. 5th December 2014, and center's affidavit is 5th December 2014.
Where do we get that?
Same volume, 1182, PDF page 1182. I'll just glance your lordships, my lord, take your lordships through, my lord, just glancing, my lord. Just, my lord, see the heading, my lord, that's all. Action plan for detection and deportation of illegal migrants in Assam and effective guarding of India-Bangladesh border. Then detection of illegal migrants, procedure for detection of pre-71. It's substantially the same we have pointed out. Procedure for detection, I'm going fast, my lord, so that it's not necessary, my lord, therefore. Procedure for detection post-71, my lord, there are, my lord, what is the procedure put in place? Then deportation of declared illegal migrants, then strengthening of foreign tribunals. That your lordships would find at 1185. My lord Justice Sundaresh.
Yes.
Then, my lord, next page, detection of names of declared illegal migrants from the, deletion of names of declared illegal migrants from electoral rolls. Then, my lord, National Register of Citizenship in Assam. Then effective border guarding for check and control of illegal immigration. It's a porous border. Now, my lord, fencing is done. There is guarding. There is, my lord, light shades, my lord, so that the infiltration still continues, my lord, which is being sought to be prevented. My lord, the rest, my lord, is the steps which we have taken, my lord, to ensure that there is less infiltration.
This data is of 2014. What is
Yes.
the present situation? How many matters are pending before the foreigners' tribunals?
Lord,
We need that from the state of Assam. The Advocate General can give us up-to-date data. So that will indicate 2,13,000 cases were pending in 2,31,000 in 2014. What is the progress? How many have been disposed of? What is the action which we are taking? Because now post 71, 6A constitutional validity is one aspect.
yes, yes.
But Mr. Solicitor, as you also say, what Mr. Diwan has argued, what Mr. K.N. Chaudhary has argued, and Mr. Ansaria, you are also not denying the gravity of the problem as it exists.
It is a serious problem.
So
Serious.
we want to know from the government of India, what are we doing now? Because this is not just about changing the demographics of Assam. That's one aspect, the cultural aspect which Mr. Diwan highlighted, but also the burden on the existing resources.
Sources, my lord, and those who should go to Indian citizens are, my lord, now being unauthorizedly shared by someone who comes only to share the resources.
People go from here to Mumbai.
Works because the affidavit says it is to be complete.
That also, my lord, as latest fencing work till date. There is one affidavit of 2018, my lord, but latest.
People got citizenship in the pre-1166 category. How many people have got citizenship, say, with the cutoff date as 1166? How many people have got citizenship 1166-25-371? And the third period is post 25-371.
When the question of citizenship doesn't.
That doesn't arise at all.
Yes,
Because post 25-371, government has to be extremely serious about what is happening on the ground.
Yes.
They may succeed on their constitutional challenge, they may not succeed, but what they are saying has a great deal of substance, not only in relation to Assam, but for the rest of the country as well.
Yes, because Lord, they are not coming here because they are persecuted or there is some problem.
Yes.
This is the second. 6 to 7. $1193.
Of how many people have entered post 25 March 1971?
Approximately.
Approximately. Because do we have any estimate of that in India? Two, how many matters are pending as we post to the Advocate General? How many matters are pending before the
Tribunals.
tribunal? How many tribunals do we have? Because frankly, we will deal with the issue of constitutional validity, which is something which we have to consider. I mean, that's a very weighty argument. But assuming everything that we affirm the validity of 6A, what are we doing post 1971?
As a matter of fact,
One other aspect which you may consider. See, our point also is that these very problems which the Solicitor General is projecting also happen in the context of Bengal, West Bengal.
We are going to come that. We come to that.
We are aware of it.
Also, when you're answering now, I think we've understood the broad lay of the matter. What we'd now like to know from you is the Article 14 argument, the cultural impact, etc. We'll hear you very briefly, but your point really will be that look, this was basically political policy, and therefore this is something which is factored in. But we'd like to hear you on that.
I'll just
But most important, why did you single out Assam when we found yesterday that West Bengal shares a much larger border with Bangladesh, and therefore, presumably, the extent of illegal migration into West Bengal would be as or even more significant? Or did we have any cogent data to indicate that the extent of illegal migration into West Bengal was minimal as compared to this? Therefore, we left it alone.
No, Lord, we don't have. And this is the answer which I am going to
So,
give, my Lord.
Now, what Maharaj is saying is that now, after Assam, this illegal immigrant will get into more and more they get into West Bengal now.
Absolutely.
What is going to see? Therefore,
It's
we want to
going on.
know how do you propose to deal with this? At least after 71, after 71.
And Mr. Solicitor, there are a couple of, we have to look at it at different layers. First, there is a layer of legality, that we deal with these illegal immigrants who are here with due process of law, because we are not some authoritarian country that you just pick them up and treat them, and show the
due
power
process
of the,
is the tribunal.
We have to follow process of law because we are a democratic country governed by the rule of law.
Correct.
And there's a grave danger that you might actually pick up if you don't follow the rule of law. Genuine people may be picked up and thrown out. That's something we must also.
Yes.
But more important than also, what are we doing from here
Onwards.
for the future? What is the government of India doing in terms of ensuring that you have an impermeable border? How much investment is the government of India taking into ensuring that the border becomes, in that sense, impermeable?
Lord, I understand.
What are the executive steps which the government of India is taking?
Lord,
Have we, to what extent has the border been fenced? We understand that parts with the terrain is impossible to be fenced also, but what are the steps we want to know? Because this is a crucial problem, independent of 6A.
1126, my Lord, may give some answer, my Lord. Lord, this is again as of 2014. This is regarding border fencing, my Lord, Justice Suryakant's query, my Lord. Lord, apropos, my lord, yes, my lord, that is given, my lord, in the affidavit. My lord. Yes, my lord. What is the process? What is the procedure followed? That is undertaken, my lord. That is undertaken. They are being subjected to the foreigners tribunal jurisdiction. The data, my lord, we will provide.
As Government of India, does Government of India have data? And Mr. Solicitor, we understand the problems of all this as well. Because culturally, you're dealing with people who look exactly like you, they speak the same language, they dress the same way.
No,
What is the data with the government? What is the extent of the illegal immigration post 71?
my lord, I'll just, my lord, point out.
Do we have that data?
No, this is my answer, my lord, not the government's answer, my lord, because I could not, my lord, get it from the record. So far as Bengal is concerned, my lord, the general discussion which I have with the officials is that Assam faced the problem and raised it at a level for the simple reason that uh, culturally, Bangladeshis and Assamese were so different that it was easy to identify. In case of Bangladesh, their language, their food habits, their dressing, everything, they mingle very easily, number one. Number two, because of that, maybe there is no uproar or something, but that does not justify the government not taking steps. I must admit.
Correct. With great respect to my learned friend, regarding races, there are a lot of difference in government. One can make out.
Between?
Why not predominantly Assam is a.
No, he is agreeing with you. He's saying
I'm supporting
Bengal. He's talking about Bengal, not Assam.
I'm talking about Bengal.
Bengal. That's why I thought I'll clarify. I got your point. We realized what was in your mind. He was talking about Bengal. But now tell us, what have we?
What I'll do is,
One way, Mr. Solicitor, their argument is strike it down under 14. You didn't do to West Bengal what you have done to Assam. You have an equal illegal immigration into West Bengal. You just let it be. Let it be in the sense they are liable to be deported. You granting them legality in Assam. One is the 14 argument. But beyond that now, we are going beyond the validity argument.
correct.
What are we doing? Why? First, we want to know what was the reason which prompted Parliament to exclude West Bengal from the grant of citizenship? We are not saying that they should have granted it. But why? What is it that led us to believe that this problem was peculiar to Assam and not to?
If
Argument could not have been from the Indian perspective that there was an agitation in Assam.
cannot.
The argument from the Indian perspective is we have to do what is good for the nation.
Yes.
Right? Why did we leave West Bengal alone? Second, what is the extent of illegal migration between 1971 onwards, and what is the position as West Bengal? And what is the government doing in West Bengal now?
I must admit, Lord, right now, my lord, my preparation was on the validity part and legal part, but matter may not end today.
So we'd like
Undertake to file an affidavit of the authorized officer, Lord, latest by tomorrow or day after, on all questions, because
we would like an updated statement from Government of India. Let the Home Secretary also apply his mind to this.
yes.
What is the Government of India doing in terms of safeguarding the border, in terms of border fencing? What is the updated position? How far is the border fencing arisen? Because this is also crucial in the sense of, we get all these matters which come up before us every day about, the...
Foreigners Tribunals Award.
No, about the people seeking bail because they've been, when they've been caught cattle smuggling, so-called cattle smuggling, involvement with the. We've also had cases, you will recall, of our own paramilitary forces officers being involved with that.
Yes.
Those people have been proceeded against.
Yes, sir.
So all this is a very serious
Well,
problem.
my lord, I undertake that Home Secretary will file an affidavit.
Bengal a party to these proceedings.
I think all states
All
are part.
states are right. You are a,
My lord, state of Tripura also has equally the same problem.
but
In fact, Tripura, it is minority.
one second, we will come to Tripura in a moment. Who's appearing for the state of West Bengal?
State is a party.
Have they filed an affidavit?
But
Have they
all
filed-
states are parties.
Mr. Diwan,
One of the-
Mr. Chaudhary, has West Bengal filed an affidavit in this proceeding?
Just check.
That is going to be a problem.
Lord, state is a party, my lord. But I will, my lord, I assure your lordships, the Home Secretary will file an affidavit on all these concerns.
We would like to
Reason
have
is
an
this.
affidavit from them also,
The
from the state of West Bengal also, their official stand we want to know.
Certainly, my lord. The reason is this, my lord. Forget, my lord, anything else. Your lordships are a constitutional court, my lord, protecting fundamental rights of every citizen. Lord, this would be a part of fundamental rights of large section of citizens, my lord, in large, my lord, in several states where, my lord, their natural resources, their other resources, my lord, are being shared only on economic grounds.
Now, Mr. Solicitor, let's go rapid fire now on your argument to
Yes, yes.
your response to constitutional validity.
Yes, kindly, my
You've
lord.
shown us the statutory scheme, right?
Yes, yes.
Just tell us now what is your answer to the constitutional challenge.
Yes, my lord, please come to, my lord, my written submissions, volume 2A.
Volume 2A.
2A, my lord. And I'll, my lord, as your lordships have said, rapid fire, I'll skip, my lord, what is, they may be treated as read, my lord, but volume 2. Lord, to page 8. I'm skipping, my lord, whatever is not relevant immediately. Lord, enactment of section 6A, the history, the background behind it, my lord. There was a debate in parliament. Your lordships may not get much on that, my lord, except that I'll just, my lord, paraphrase so that your lordships may not have to read. Assam Accord provided and the government has agreed, that is one. Number two, at the relevant point of time, the war. And therefore, people have come. And most important, my lord, your lordships would get at page 10, because there was an argument of Article 11, my lord, that this amendment is virtually amending Article 4 and 5. Lord, that was 4, 5, and 6. I'm sorry, 5 and 6. Lord, that was, my lord, dealt with when 6A was being framed by the then Home Minister, my lord. Please see, my lord, page 9, Shri S.B. Chavan, the then Home Minister. Page 10, my lord. Page 10. Your lordship gets, my lord Justice. I am also referring to Article 11 of the Constitution, which clearly lays down that government is within its own powers to enact legislation conferring or terminating the citizenship, any of the rights which a citizen can possibly have. So this is a very wide power which has been provided for. There is no question of any infirmity under the Constitution or any other law for the time being in force. Lord, then your lordships can skip the rest. Then and come to, my lord, page
Just
11.
that little part PDF to that part in the middle. We have made a commitment
Yes, Manoj, that's what I said.
That is a little important because
We
you
have
said,
made a commitment to stop a large number of infiltrators who have been crossing over. The average rate comes to about 2,400 per month. All these people have been trying to cross, and we have been trying to push them across the border. There is no denying the fact that the people have come. Whatever Bangladesh government might say, I can say without any fear of contradiction that in fact, a large number of people have come. But they had come in a very peculiar circumstances, and that is why we could not possibly afford to take very harsh attitude, and that is why conciliatory attitude had to be taken, and that is why legislation is there. Look, it says about post pre-71, but admitting the position that this position has continued even after 71.
what was the statement of objects and reasons of the bill introducing Section 6A? What did the statement of objects and reasons say?
My lord, to give effect to the Assam Accord, I tried,
That's all.
but my lord, your lordship did
Nothing
not
beyond
get any
that.
assistance from that. Therefore, my lord, we tried and searched the debates of Parliament. Then, my lord, at the foot of page 10, the bold part, Sri Bhadra Pratap Singh, this unprecedented situation was not contemplated by 1955 Act. Therefore, this present amendment is trying to solve that situation, and Parliament is competent under Article 11 to enact this kind of a legislation. Then, my lord, Mr. P.A. Sangma's, my lord, is relevant at page 11. He was, my lord, MOS in Department of States. Members from this side and the other side, including, I think, Mr. Babul Reddy himself, have pointed out that Parliament is competent to decide on all matters relating to citizenship. And this has been very clearly, very expressly, unambiguously put forward in Article 11 of the Constitution. Therefore, the constitutionality of this bill cannot be doubted. The power of Parliament to enact such a bill cannot be challenged at all. My lord, on 11, let me, my lord, complete my submissions in 5 minutes. My lord, A. And my lord, there is a interesting Constituent Assembly debates when 11 was being framed.
Yes.
They say that we have to leave it to the Parliament. How? My lord, Article 4, Article 5
formulated ABC.
It is there. It is there. But my lord, I'll just orally point out and then my lord show your lordships. Lord, Article 5 and 6 talks of deemed citizenship. That if you are born or if you have come before a particular date, Article 6 and 7.
6 and 7.
6 and 7, I stand corrected. Then you are deemed to be a citizen of India.
Yes.
That was when the Constitution was framed. Subsequent to the Constitution, there may be situations where the nation needs to confer citizenship on various other grounds or take away somebody's citizenship on certain grounds, and therefore Article 11.
Acquisition and termination.
Yes. So 6 and 7 are deemed citizenship when Constitution came. 11 is for future contingencies. Second, and my lord, this is on textual reading only. If 6 and 7 were to be frozen in time, as argued by the petitioner, then why have 11 at all? Then 6 and 7 is complete code. There cannot be any additional reasons for conferment of citizenship, or there is no provision for taking away citizenship.
To which their answer would be that Article 6 and 7 is Pakistan specific. That it basically deals only with Pakistan, right?
Correct, my lord.
So the purpose of 11 is broader. 11 covers, but it will, Article 11 would not cover only Pakistan. It will cover the entirety of
The entirety of the world. Well, there may be several citizens, for example, my lord.
The argument was that once, which you have to deal with, which is that once the date of 19 July 1948 is chosen in Article 6 for the conferment of deemed citizenship, then the argument was that you can't, by the exercise of an ordinary legislative power, reach that date of 19th of July 1948 because Bangladesh, 25 March 1971 and prior thereto, Bangladesh is a part of Pakistan. The area of Bangladesh now, specified territory is a part of Pakistan. Albeit is Pakistan. Now, therefore, the argument is that you can't, in respect of a period covered when the specified territory was in fact a part of Pakistan, can't confer by deeming citizenship, by deeming an act of citizenship, because 6A also is deeming
Confer
citizenship.
but not deemed.
You can't, yes, you can't, because you are making a deeming fiction. And that deeming fiction can't transgress the limitation which has been prescribed in Article 6. That's the argument.
Answer your lordships would get from the Constituent Assembly debates, which I have quoted, relevant part of only
Where is that?
Article 11. Because the theme is
वो बंद कर देना। उसमें
they won't send to us, right?
one answer to that which we put to them was that Article 6 deals with the position as of the date of the adoption of the Constitution.
That's
It
what
basically dealt with the historical context of partition. Article 6, the answer probably would be that Article 6 does not tie down the hands of a future parliament to decide to
the
confer
contingency is not contemplated.
in Article 6. Article 6 can't be regarded as an exhaustive universe. That would be the simple answer, I think.
Your lordships would see Article 6. They say at the commencement of the Constitution. So, and they say very categorically while drafting the Constitution, while Article 11, that we may not be able to conceive of situations which might arise in future.
It's a declaration of citizenship for a group of people under the Constitution. That's
At
all.
that point of
That's
time,
over. That's
under
over.
those circumstances.
To accept their argument would mean that Article 11, the ambit would be to all countries other than Pakistan.
Yes.
Because that would be perhaps a very narrow reading of the power which is conferred by Parliament.
Another thing, apart from the fact that Article 11 starts with nothing in the foregoing provisions,
It's a non-obstante clause.
initially when it was introduced as a draft, it said further provision governing citizenship, which was deleted consciously. But just give me 5-10 minutes. Can I please come
Where
to
is
page 12, 14 of my written submission. 13 starts with drafting history of part 2, entire part 2, but we are more concerned with Article 11. Para 37. Does your lordships get it? 37. On 29th April 47, while moving clause 3, Sardar Patel requested that the following should be added to clause 3, thereby empowering the union. Further provision governing union citizenship may be made by laws of the nation. This was, my lord, the beginning of Article 11. This was conceived by Sardar Patel, my lords. My lord, thereafter, your lordships may, my lord, directly come to, Lord, it was referred to a committee. Please come to para 44. And the redrafted clause by the committee is, my lord, at para 44. It went before three different committees, my lord, this Article 11 issue. Thereafter, Sri B.N.
The
Rao,
constitution of the committee, it had Vardacharya,
my lord, all were eminent, my lord, please
K.N.
see.
Mittal, Alladi Krishna, Alladi Krishna,
Kanayalal Munshi, K.N.
K.N.
Kaju,
Kachu, Munshi, and
Munshi
Dr.
and
Ambedkar.
Dr. Ambedkar himself. We were fortunate to have, my lord, this constitution because of, my lord, people of this eminence and intellect. Then, my lord, what they suggested was every person born in India, in the union, and subject to its jurisdiction, every person either of whose parents was at the time of such person's birth a citizen of union, and every person naturalized in the union shall be a citizen of union. Further provision regarding the acquisition and termination of union citizenship may be made by the law of the nation. Still further word remained, my lord. Thereafter, my lord, it was redrafted, and your lordships would find at page 44, para 3 only, my lord. Further provisions governing the acquisition and termination of union citizenship may be made by union law, that is parliamentary law. Then 45. Meanwhile, the Union and Provincial Constitution Committee at their joint sitting on June 5 appointed a subcommittee to consider in detail the effect of June 3 plan. My lord, that is Mountbatten plan. My lord, it's referred to as June 3 plan. The joint subcommittee met on June 8 and decided that the question of nationality and citizenship in the union should be re-examined by the ad hoc committee in light of the plan. In the report submitted by the Assembly on July 4, the Union Constitution Committee incorporated the citizenship provisions contained in the memorandum without any change, except that the word union was replaced by the word federation. My lord, your lordships can skip that. And, my lord, please see the committees, my lord, is quoted, my lord. In this connection, my lord, page 16 top. In this connection, the committee quoted with approval the view of Calcutta Law Journal. It is not possible to define exhaustively the conditions of nationality, whether by birth or naturalization, by the Constitution. If certain conditions are laid down by the Constitution, difficulties may arise regarding the interpretation of future legislation which may appear to be contrary to or to depart in any way from them. The exact argument which is made. It would, in our opinion, therefore, be better to specify who would be citizens of Indian Union at the date when the Constitution comes into force, as in the Constitution of the Irish Free State, and leave the law regarding nationality to be provided for by the legislation by the Indian Union in accordance with accepted principles of private international law. But this gave birth to Article 11. But it is now in the evolution process, my lord. My lord, please see para 48. When the draft was presented, but I will not read, there were 140 amendments to the Constitution. Dr. Rajendra Prasad was pleased to say that you have it as a composite thing. Don't go one by one, but not relevant. Please come to para 50. Am I with you?
Yes, sir.
Para 50. The Constituent Assembly debates with regard to citizenship and especially Article 11. Lord, it was draft Article 6. So somewhere there would be a reference of Article 6, but that is present 11. Is illustrative and clearly points towards an overarching power being available to the Parliament. The following are the debates. Dr. Ambedkar, Mr. President, sir, except one other article in the draft Constitution, I do not think that any other article has given the drafting committee such a headache as this particular article. I do not know how many drafts were prepared and how many were destroyed as being inadequate to cover all the cases which it was thought necessary and desirable to cover. It is not the object of this particular article to lay down a permanent law of citizenship for this country. So it is very categorical. The business of laying down a permanent law of citizenship has been left to Parliament, And as members will see from the wording of Article 6, which is present earlier, my lord, avatar of 11, as I have moved, the entire matter regarding citizenship has been left to Parliament to determine by law that it may deem fit. The effect of Article 6 is this, that Parliament may not only take away citizenship from those who are declared to be citizens on the date of commencement of this constitution by the provisions of Article 5 and those that follow, but Parliament may make altogether a new law embodying new principles. They must not understand that the provisions that we are making for citizenship on the date of commencement of this constitution are going to be permanent or unalterable. All that we are doing is to decide ad hoc for the time. I don't think with respect there can be anything more clear than this. Then, my lord, next Dr. Rajendra Prasad, my lord, only highlighted part I may read. I would therefore suggest that amendments of this nature might also be left over to be dealt with by Parliament at a later stage, and we might confine ourselves to the limited question of laying down the qualification of citizenship on the day of Constitution came into force, as my lord, the Chief Justice, my lord, said. Then, my lords, your lordships may kindly come to page 19. There are other, my lord, honorable members saying the same thing, but page 19 is Lord Dr. Alladi Krishnan, Sri Alladi Krishna Swami Iyer, my lord, at page 19, my lords.
Yes.
Sri Alladi Krishna Swami Iyer, the articles dealing with citizenship are therefore subject to any future nationality or citizenship law that may be passed by Parliament. Parliament has absolutely a free hand in enacting any law as to nationality or citizenship suited to the conditions of our country. It is not to be imagined that in a constitution dealing with several subjects, it is possible to deal with all the complicated problems that arise out of citizenship. Then, my lord, Hridaynath Kunzuru also, my lord, only highlighted part. There is nothing permanent about the qualifications laid down in Article 5 to 5C. I'm sorry.
Yes.
5 to 5C. Article 6, that is 11 present, my lord. Slight modification that further becomes, my lord, nothing contained. Article 6 makes it absolutely clear that notwithstanding the provisions of these articles, Parliament will have power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Any defects that experience may disclose can therefore be easily rectified. The Parliament get experience, they need more qualifications, they need to take away citizenships, not concerned in this case, but generally.
Yes.
Sorry, I did something, yes. Lord, now, my lord, your lordships have, my lord, on the last day when my learned friend was distinguishing the judgment which I was to cite, have seen, my lord, at page 21, on interpretation of Article 11, that is, my lord, Izar Ahmed Khan versus Union of India. My lord, this is the judgment by 5 honorable judges, my lord. I'll read the highlighted part. It's, my lord, authored by my Lord Justice Gajendra Katkar. Lord, at page 21, bottom highlighted part. Article 11 confers and recognizes the power of Parliament to make any provision with respect to not only acquisition, but also termination of citizenship, as well as all matters relating to citizenship. Thus, it would be open to the Parliament to affect the rights of citizenship, and provisions made by the parliamentary statute in that behalf cannot be impeached on the ground that they are inconsistent with provisions contained in Article 5 to 10 of Part 11, Part 2. So clear that 11 is an independent power and it can add to.
Just read the next sentence also. In this connection.
Yes, I'll just, my apologies. In this connection, 246, it is important to bear in mind that Article 11 has been included in Part 2 in order to make it clear that the sovereign right of Parliament to deal with citizenship and all questions connected with it is not impaired by the rest of the provisions of the state part. Therefore, the sovereign legislative competence of the Parliament to deal with the topic of citizenship, which is part of entry 17 list 1 of the 7th schedule, is very wide and not fettered by the provisions of Article 5 to 10 of Part 2 of the Constitution. This aspect of the matter may have relevance in dealing with the contention raised by the petitioners that their right under Article 19 are affected by the impugned provisions, etc. So, my lord, this is the only judgment, my lord, on Article 11. But even textually, and keeping in mind the drafting history, the only inevitable conclusion is that they say we cannot conceive of many future situations, we leave it to Parliament. So, my lord, this distinction between deeming or conferring, lord, may pale into insignificance. My lord, page 24, your lordships may not read. I have just given, my lord, the words which are used in the Article 11, which starts with nothing in the foregoing provisions, Lord, are used only in these articles. So it is, Lord, elevated to that level. That's all, Lord. Nothing beyond, Lord, turns upon that. Lord, Article 324, my lord, my learned friends have not also, Lord, seriously pressed, my lord, so I'll not trouble your lordships with that. Please directly come to page 29, my lords. He also did that. My lord, Sarvanand Sonowal judgment, I have just said, my lord. Sarvanand Sonowal judgment was concerned with one act.
MDTR.
And the argument was that look at the serious situation on ground. This act does not fulfill the object it seeks to achieve. And on that ground, Sarvanand Sonowal was, Lord, declared, was pronounced, and that act was declared unconstitutional. It, in fact, supports that this is a huge problem. But your lordships are not, my lord, right now concerned with right, Lord, correctness or otherwise of this judgment. Then, my lord, scope of judicial review in relation to treatment of foreigners, my lord, I may not trouble your lordships with. Lord, please treat this as read, my lord, because your lordships are aware of the settled propositions of law on this. Please come to page, Lord, 34. Lord, challenge concerning Article 14. Where I'll read, my lord, only one or two judgments, my lord. At page 35, this is a judgment by 7 honorable judges, special court bill. Only 71. There are numerous cases which deal with different facets of problems arising under Article 14 and which set out principles applicable to questions which commonly arise under that article. Among those may be mentioned the decisions of so-and-so, so-and-so. Then, my lord, highlighted part. But as observed by Justice Matthew, in the last mentioned case, it would be an idle parade of familiar learning to review the multitudinous cases in which the constitutional assurance of equality before the law has been applied. But, my lord, thereafter, my lord, at page 36, the Honorable Court, 7-judge bench, my lord, earmarks what are the contours your lordships would consider while my lord, examining a challenge under Article 14 and relevant, my lord, all are relevant, of course, my lord, but please come to 5, just, my lord, at the foot. On the classification, my lord, my learned friend's argument was there is a classification. Well, I'm dealing with that submission, my lord. By the process of, your lordship gets that, my lord. By the process of classification, the state has the power of determining who should be regarded as a class for the purposes of legislation and in relation to a law enacted on a particular subject. This power, no doubt, in some degree is likely to produce some inequality. But if a law deals with the liberties of a number of well-defined classes, it is not open to the charge of denial of equal protection on the ground that it has no application to other persons. Classification thus means segregation in classes which have a systematic relation usually found in common properties and characteristics. It postulates a rational basis and does not mean herding together of certain persons and classes arbitrarily. The law can make and set apart the classes according to the needs and exigencies of the society and as suggested by experience. It can recognize even degree of evil, but the classification should never be arbitrary, artificial, or evasive. The classification must not be arbitrary, must be rational, etc., etc. My lord, your lordships are well aware of the propositions, my lord. So I'll not, my lord, trouble your lordships with that. Please, my lord, come to the case of, my lord, Ajayab Singh, which is at page 38 at the foot, my lord, para 111. That, my lord, lays down substantially the same test. My lord, I may even, my lord, skip that. So please come to page 40. My lord, under classification. My lord, I'm duty bound to answer on facts on the question of Bengal. But my legal proposition, my lord, is this. And I will do that, my lord, in the within a day or two by way of an affidavit filed by the Home Secretary. But the argument is, instead of 1, you should have done it for 5. So argument is of under classification. That may require law to be made for others, but would not be a ground to declare the law already made ultra vires. Lord, first judgment is N. Venugopala Ravi Verma Raja versus Union of India. And please at page 41 see, my lord, the highlighted part. So under classification is always not a, my lord, ground of a successful challenge on Article 14. But the mere fact that the law could have been extended to another class of persons who have certain characteristics similar to a section of Hindus but have not been so included is not a ground for striking down the law. In treating a Hindu undivided family as a unit of taxation under the Expenditure Tax Act and not a non-Hindu undivided family, the Parliament has not attempted an obvious inequality. Then, my lord, Ajay Kumar Banerjee, only highlighted part, we may reiterate that Article 14 does not prevent legislature from introducing a reform, that is, by applying the legislation to some institutions or objects or areas only in according to exigency of the situation, and further classification of selection can be sustained on historical reasons or reasons of administrative exigency or piecemeal method of introducing reforms. Maybe for other states law may come, but that would not make 6A ultra vires. So special provision for one state historically because of Assam Accord, etc.
Yes.
Yes, but kindly Ambika Mills, my lord, is a settlement. I'll not read that, my lord. Then territorial classification, your lordships would get, my lord, 43, page 43. Territorial classification is justifiable. Well, this is my submission in law. But factually, since it has fallen from the court, my lord, and the court, which is a constitutional court, taking care of fundamental rights of everyone present here or otherwise. Lord, I must answer the question regarding, my lord, territorial classification. Why not Bengal? Why only one state? Why not Tripura, etc. Lord, ODL, my lord, your lordships are aware, my lord, I'll just read the highlighted part. Historical considerations and compulsions do justify inequality and special treatment. Then, my lord, next page, next para, highlighted part. And if after reorganization of states and integration of the PEPSU Union in the state of Punjab, different laws apply to different parts of the state, that is due to historical reasons, and that has always been recognized as a proper basis of classification under Article 14. Then, my lord, state of MP versus Bhopal sugar mills. Your lordships will come to next page directly, my lord, at page 44. The legislature, my lord, I'm reading the highlighted part. The legislature has always the power to make special laws to attain particular objects, and for that purpose has authority to select or classify persons, objects, or transactions upon which the law is intended to operate. Differential treatment becomes unlawful only when it is arbitrary or not supported that by a rational relation with the object of the statute. This court has held in several cases that where application of unequal laws is reasonably justified for historical reasons, a geographical classification founded on those historical reasons would be upheld. Lord, the same thing is, my lord, Lord, rest as settled propositions, if your lordship permits, I may skip, my lord, because just, my lord, your lordships gets our side of, my lord, judgments on one, in one submission, my lord, I have yes. My lord, one last point, my lord, page 49.
Yes.
On classification where the law is made only for Assam. I'll just, my lord, paraphrase my submission, not going into it. There are several provisions under the Constitution of India which applies only to particular states, including the state of Assam. So there can be a law applicable only to one state. Lord, page 49, I have, Lord, pointed out the provisions which are applicable only to Assam. This is on, my lord, the classification based on territory.
Yes.
My lord, these are my respectful submissions. Only one thing, my lord, as a last thing, as I, my lord, I have some kind of an apprehension. My lord, I would request the interveners to keep in mind that they are here to protect 6A, meaning thereby they represent people from 51 to 71 and not post 71. So, my lord, their submission may not be such that though we are on the same side, I have to give rejoinder to them. That's all. My lord, I am
confined to the validity of 6A.
only validity of 6A.
Right.
Yes.
Mr. Attorney General, should we hear you right after lunch?
Lord,
Because we're
after
almost in the
lunch-
stroke of lunch.
After lunch, whatever details, my lord, I could get, I would submit before your lordships in 2 minutes, my lord. During lunch hours, we'll do that. And it would also be a part of my affidavit, which I file latest by day after.
But in the event your lordship don't finish today, what is your lordship planning to do, my lord?
How long would you take, Mr.
Not very long, my lord. I think my
Mr.
learned friend
Attorney
has
General,
covered.
Mr. Attorney General, how long would you take? Because I think this has been covered substantially now. Mr.
I have
Sibal,
brief
about the
note.
same?
That's fine, my lord. There's no problem. Then
And, Ms.
I won't
Jaising,
take very long.
Ms. Jaising, about the same time, I think?
About the same time as Mr.
All right. And then we can ask them to complete their rejoinder today then.
Just take a period of time. I have that one pager that my lords had said.
Fair enough, we can give you a one pager. So once,
Just summarize.
so what we can do is suggest is this. We start at 2 o'clock. We request all of you to, we have Mr. Attorney General, Mr. Sibal, Ms. Jaising. If you can conclude by, say, by 3 o'clock.
Not possible.
Mr. Attorney is saying 15 minutes.
I have a
15
note which I'll read.
Yes, say 10 minutes for the attorney, say 10, 15 minutes.
Whatever your lordship says.
So what we are suggesting, if you finish it by 3 o'clock, then we can give them an hour for rejoinder and then conclude the matter thereafter.
Anyway, my lord,
Anyway, we'll see how it goes. We'll see how it
By
goes.
way of anything,
May
Yes,
I take your permission, my lord, to file a list of dates, reference to the compilation? It'll
absolutely.
speed up everything because no one has really filed a list
Is
of
it
dates.
already, is it, I just saw a list of dates in the attorney's written submission.
In my note, there is, but I skipped it because that was argued before it.
Ms. Jessie,
Yeah.
is your list of dates part of what you have filed in the soft form?
Compilation, no, it's reference to the compilation already filed. All the dates
No,
are
I'm asking
available
something
in
else.
the
Is
compilation.
your list of dates already in the electronic record which is made available to us?
No, my lord, not in the electronic record, it's culled out from the electronic record.
Then why don't you do this, maybe over lunch, just the list of dates, you
Yes.
can email it to the court master, so you
Yes.
can then tag it as a volume, so we all 5 of us will have it.
So,
You can do that.
because I have
And with
also
copy
just
to all of us, my
response to my learned friend's argument, just made a 5-pager, my lord, that can be uploaded.
All right, then Mr. Sibal and Ms. Jaising's brief note, and anybody else who has that one pager, please over lunch, over lunch, give it to the nodal council.
Yeah.
There's a nodal council in this
Yeah.
matter. Nodal council will upload it and give it to the court
Well,
master.
if I may be permitted to upload the one pager, not today, but tomorrow, because I have longer than one page, which I would like to edit down to one page. So-
That's a very fair suggestion.
Easy.